Welcome on behalf of Associated Builders and Contractors of Western Washington's Professional Development Council and Legal Action Committee, and thank you for tuning in. My name is Jared Malone, Membership Development Manager here at ABC, and I would love to chat with you more about the many benefits of your membership. In the meantime, please enjoy this Work in the COVID-19 Era presentation where Darren Feider with Sebris Busto James provides a 30,000-foot view of the implications of COVID in the workplace.
Good morning. My name is Darren Feider. I'm a shareholder in the law firm of Sebris Busto James. Sebris Busto James is a small labor and employment boutique. We have 12 attorneys and we practice only employment law and only defense of employers. I practice management side employment law since 1990. The topic is work in the COVID-19 era. We're going to cover the new emergency paid sick leave laws, FMLA leave, OSHA, and various other laws. The Family First Coronavirus Response Act is probably the biggest piece of legislation that's been passed in the last 20 years. And it was passed in 1 month. So there's a lot of changes that have occurred because of this new law. We call it the FFCRA. It was passed on April 1st. Some people say it was a joke. I don't think it's an April Fool's joke. I think it has a lot of implications for employers like yourself. The obvious implications are the emergency paid sick leave law you've probably heard about, emergency FMLA law, and then the pandemic unemployment program that sunsetted but is coming back beginning of the fall of 2020. Less obvious implications are paid safe and sick leave laws. How do they interact with the new FFCRA, the ADA or the disability laws? How do they interact with the COVID-19 and people who contract COVID-19? Unemployment compensation, has it been changed because of the laws? Wage and hour law, there's big issues with COVID-19 and people working at home and not working at home, and how do you pay them? OSHA, of course, and WISHA, safe workplaces are being impacted by COVID-19 and the general duty to ensure that you provide a safe workplace. And basically age and disability laws are issues. The hidden claim out there that very few people know about is all these laws have a claim for retaliation. In other words, if you fire someone because they assert that they're entitled to leave, even if they're not entitled, they may have a retaliation claim. In other words, your employees will be protected under these laws, even if they're wrong. Right now, the lawsuits are rolling in. People are suing because they didn't get their leave. They're suing because they haven't been reinstated to work. They're suing because they're being fired because they don't come back to work. So the impact of COVID-19, I really believe, is going to be substantial. And in 2021, the lawsuits will all start piling up. The goal of this presentation is not to go in detail about every single law or to take days to do it. What I want to do is give you a high-level understanding of the laws. If you have any questions, you can then go speak to your attorney or anyone else to get help. So let's start with the very first law, which is the Family First Coronavirus Response Act. It is emergency paid sick leave. This is a new federal leave. It's a leave that didn't exist before COVID-19 happened. And how much did you get under the law? Well, an employee gets 80 hours of paid sick leave. That's in addition to any paid sick leave they have. The limits are $511 a day or $51,110 total for employee. And an employee takes leave to care for their family member, it's $200 a day with a max of $2,000 total. So this is in addition to, and you'll notice it's in hours. In other words, they're not getting weeks, they can take hours. So they can take an hour here, an hour there. How do you calculate 80 hours of paid leave? Well, the hourly rate is determined by taking the employee's total compensation and dividing all hours worked, and then you come up with a rate of pay. Why that's relevant to people is if you have someone who's working on a piece rate basis, who receives a bonus, who's paid in commissions, all that compensation has to be considered when you come up to an employee's rate of pay. The limits, of course, are as much as they'll ever get under emergency sick leave. Now, these 80 hours of paid sick leave are in addition to whatever else leave they may have under laws, such as the Paid Safe and Sick Leave Act, the Seattle version of it, or even the Washington Paid Family Leave Act. These are 80 extra hours. Who's eligible for this? Well, first of all, you have to be unable to work. And what I mean by that is if an employee is able to work, then he or she is not entitled to leave just because we're in this COVID-19 period of time. They have to be unable to work. And when are they unable to work? Well, there are 6 basic reasons. And if these 6 reasons don't exist, the employee is not entitled to the emergency paid sick leave. What are they? Well, they're quarantined or they're been subject to an isolation order because of COVID-19. They've been diagnosed with COVID-19 and they've been advised to self-quarantine. They're experiencing symptoms and seeking medical diagnosis. They're caring for a family member who has COVID-19 or experienced symptoms and seeking a medical diagnosis. Childcare because school has been canceled, or when we were in the summer programs have been canceled, or they're experiencing a substantially similar condition. That number 6, not defined. So what do we take from this? Well, number 1, the employee must be unable to work or to telework in order to receive the emergency paid sick leave. If they can work at home, they don't get emergency paid sick leave. Number 2 is people don't understand clearly is if you have to be available to work. And what I mean by that is if you're furloughed, if there's no work, if the company is shut down, there is no right to receive emergency paid sick leave. That is the condition preceding to receiving it. And as I'll say for the 3rd time, this leave is in addition to other leaves you may have. So in addition to emergency paid sick leave, there are some rules that you should be aware of. Number 1 is it's only available from April 1, 2020 to December 31, 2020. It's going to sunset at the end of this year. Is that a guarantee? Absolutely not, because we're going to have a second wave, if not a 3rd wave. And today there's congressional negotiations about extending the leave. So learning about this leave in itself is not a problem, because I think probably it's going to extend beyond December 31. What type of employers are covered? Well, less than 500 full-time or part-time employees. In other words, you have to be under the 500 bar. Large employers are off the hook. Not sure why, but that is a decision made by the federal government. How do you count 500 full-time or part-time employees? Everybody's counted. Full-time, part-time, those on leave, those who are temporary employees, day laborers. And if you're a joint employer, 2 employers who are related, they all count to see whether or not you get over the 500 threshold. It's strange, but it's true. It seems like Congress is trying to protect larger employers from exposure under Family First Coronavirus Response Act. Also, small employers can be exempt. And I use the word can because you have to prove 2 things. A small employer need not provide emergency paid sick leave if the paid leave will cause them to cease operations, or second, the people who are gone because of the leave will cause them to cease operations. Absent that, small employers have to provide paid sick leave. So basically, this is a law for the mid-sized companies. By the way, employers have an obligation to inform their employees of the rights under the law. So if you haven't done that, you go onto the internet and you can get the notice if you want from the Department of Labor. Some reminders under the emergency paid sick leave law. Number 1, well, I just said that. You need to inform your employee of their rights under FFCRA. 2, you can't take any adverse action because of the usage. What does that mean? If an employee reports that she has COVID-19, that her child has COVID-19, that she cannot come to work because her child's not at school, and that's impacting your business, and you have to go out and hire someone to fill that spot, that person is job protected if they're taking leave under this law. So no adverse action. And then just because employees who are exempt, like salaried supervisors, HR managers, or your professional employees, if they take leave, the exemption is not lost. So that's the first expansion of the law. The second expansion under Family First Coronavirus Response Act is the expansion of FMLA. This is the first time in 27 years since the FMLA has been expanded. This is a big change in the law. So what's the first big change? Well, under the Family First Coronavirus Response Act, an employee may take up to 12 weeks of paid leave for childcare. And I use the word paid leave because if everyone knows, under the FMLA, it's unpaid. So this is a substantial change in the law. It also lowers the eligibility, and we'll talk about that, who can take the law. So this is the second new paid leave law that has come out as a result of COVID-19. Now, how much do they get? Well, they get 2/3 of their regular rate of pay, And we talked about how you determine the regular rate of pay. You take total compensation and you divide it by hours worked. You come up with the regular rate of pay, and they get 2/3 of that. The first 2 weeks are unpaid. The reason why the first 2 weeks are unpaid is because Congress assumed that you would take emergency paid sick leave for the first 2 weeks. So you take the first 80 hours and then you get another 10 weeks total to take care for childcare. Now there are limits. You only can receive up to $200 a day and $10,000 total under the emergency paid FMLA. So the total exposure on these two laws is $12,000 for any employer. Now, here's some things you should be aware of. Number one is FMLA in itself is not expanded. So you get 12 weeks. So if the employee has already taken 10 weeks before he asks for emergency FMLA to care for his child because school has been canceled, that person only gets 2 more weeks. So 12 is the max that you can get under the law. FMLA itself hasn't been expanded, just as they've created new paid leave. Number two, big change is it covers part-time employees. Everyone knows to get FMLA, you need to work for 1 year. And during the last year, you have worked at least 1,250. Generally, part-time employees don't work 1,250 hours. So this law applies to part-time employees. What do they get? Well, you divide their part-time hours into the 12 weeks and you come up with how much they're going to receive. When do they get to take care? Well, as I said earlier, a child, they can care for their child. And what is a child? Maybe I should stop and stop talking about that. A child is anyone under 15. And you can take this leave only when there's no one else to care for that child. So a child under 15 and there's no one else to care for, when his or her school, summer camp, or place of care is closed or childcare is unavailable due to COVID-19 reasons. So if daycare is closed, then that individual can take up to 12 weeks of paid leave at 2/3 his regular rate of pay. Who's eligible for this expansion? Well, this is part of the new law that didn't exist before April 1, 2020. Any employee who has worked at least 30 calendar days. So let me stop there and be very clear about this. That is a drastic change under FMLA. To be eligible for FMLA until the coronavirus pandemic, you had to have worked at least 1 year. So this is a substantial change in the law. A couple other issues. School's back. So what do we do with school returning? And the Department of Labor has answered it for us. You can take emergency FMLA leave in the following situation. Number one is if the school is closed and the student is studying virtually, you're eligible to take emergency FMLA leave if, of course, the child is not in high school. Two, if you choose not to take your child back to school because you're concerned about the dangers there, then you're not eligible for FMLA leave because you have chosen not to go back. Paid sick leave is only available if the child is self-isolating in this situation or has COVID-19. In other words, you have to go back to the first thing we talked about is emergency paid sick leave. You can't use emergency FMLA leave if you choose to not send your child to school. And the third example is you have schools that go in and out. In other words, one day it's virtual, one day you're there, and that's they rotate the children through. In that situation, children who are rotating when the child's at home, one can take emergency FMLA leave. When the child's at school, one cannot. So those are the two biggest changes in the laws since the COVID-19. These laws were challenged in New York. In August of 2020, the U.S. District Court in New York rejected several key provisions of this law. And they're basically all the employer-friendly provisions were rejected. And let's quickly go through them. First one was work availability. The district court in New York said work availability is stupid. We're in a pandemic, and if someone is on the payroll, then they should be able to take emergency FMLA or emergency paid sick leave. So that, of course, encourages employers to get people off payroll. So if you're furloughed, you have a lack of work, you're a non-essential worker, you're still eligible to receive sick leave, paid sick leave or paid FMLA leave. The Department of Labor responded in September and said, you're wrong. Work must be available. So the Department of Labor reaffirmed its rule because you get leave from work. And if you're not working, you don't get it. Next issue is that the district court in New York in August of 2020 said the definition of healthcare is ridiculous. Healthcare providers, by the way, are exempted from the law. They don't get to take it. And that makes sense, of course, because you want to have healthcare providers available to treat people. So the district court in New York said the definition of healthcare providers is so broad, it could actually include a janitor, a librarian, the kitchen staff. And so the Department of Labor actually conceded and said the definition of those who are exempt from receiving benefits under the law only applies to employees who provide patient care. It's basically the FMLA definition of a healthcare provider. So anyone who provides care is exempt from receiving leave. Next thing, intermittent leave, the bane of all employers. Employees who take intermittent leave under FMLA drive most employers crazy because on a drop of a hat, this individual must leave because of a serious health condition. And so under the Families First Corona Response Act, the Department of Labor said you cannot take intermittent leave with your 80 hours. You cannot do it with your FMLA leave without the consent of your employer. And the district court in New York said, sorry, that's a dumb rule, and rejected the rule. The Department of Labor in September doubled down and said, we reaffirm that you need employer consent to take intermittent leave because of the work disruption that it causes with people in and out of work. The only time you get to take intermittent leave when you're using leave under the Family First Corona Response Act is with schools. So when a child, as we said just a slide back, a child has a day in, a day out, a day in, a day out of school, then you can take intermittent emergency family leave. The final point that the court attacked was documentation. Under the first version of the law, an employee needed to provide documentation before she took her leave. And the district court said, that's ridiculous because when you get sick from COVID-19 or you're feeling the symptoms, you don't have time to get leave to get a doctor's note. And the Department of Labor conceded again. They simply said, okay, you need to give written notice to your employer as soon as practicable. So soon. So those are the revisions to the law that have happened in September of 2020. So we have two new laws that are designed to protect people from giving them extra sick leave and helping them care for their children who are out of school. But it's not just these new laws that have been impacted. First, we'll talk about Family and Medical Leave Act. Generally, everyone knows that FMLA is available. You have 12 weeks of unpaid leave. I underlined and highlighted this because, of course, under emergency FMLA leave, it's paid. That's a big change. But under standard FMLA, it's unpaid. And the Department of Labor has been clear is unless you're taking leave under those 6 reasons, or you're taking it to care for your child because the school has been canceled, it remains unpaid. In other words, the FFCRA doesn't change FMLA across the board, only in the situation involving a child care or someone who's taking sick leave. Who do you get to take FMLA leave for? Well, employee or a close family member when he or she has a serious health condition. The only changes that were brought to the front as a result of COVID-19 as it relates to FMLA is 2 of them. Number one is that telemedicine is acceptable. It wasn't acceptable before. Now you no longer need to have an in-person visit under FMLA to qualify for FMLA leave. 2, electronic signatures are sufficient now. In the old days, electronic signatures were not sufficient on a doctor's note. So in a sense, we've moved forward, at least in the documentation part of FMLA as a result of COVID-19. But COVID-19 and the FFCRA do not turn all FMLA leave into paid leave. All right, so let's talk about other state leave laws that would apply to you in Washington. First of all, we have the Washington Paid Family Leave Act. It's administered by the Employment Security Department. It's a payroll deduction. In other words, it comes off an employee's wages. Both the employer and the employee contribute. The eligibility is far lower than FMLA. And it covers a broader group of people. But the question really is how does Washington paid family leave interact with these paid leaves we just talked about, the emergency paid sick leave and the emergency FMLA leave? I think the answer is they're going to stack. So what I mean by that is an employee can take 80 hours of federally guaranteed emergency paid sick leave. Then she can take whatever paid family leave she can take under the law. Now, the law provides 12 weeks of paid family leave up to $1,000 a week. So as you can imagine, if you're first of all making $511 a day, which is the cap on emergency paid sick leave, you're quickly going down financially when you're taking Washington paid family leave. But you get to take that, so you can extend out over time a period of time you're not coming to work. When do you get to take it? Well, obviously, if you have a serious health condition or a family member has a serious health condition. So once your time is expired, so say someone has COVID-19, they take 80 hours of sick leave, and then they're allowed to take FMLA leave or Washington paid family leave. As I say here, they run concurrently, so you run both of them at the same time. So the employee gets 2 weeks of emergency paid sick leave, and then they can take up to 12 weeks of paid leave under the Washington Family Leave Act. And then, of course, and we'll talk about this, if you have any paid safe and sick leave, you can take more paid safe and sick leave. So you build up over time the amount of leave you can take. The key thing about Seattle's paid safe and sick leave is there's been an expansion. The city council said that a family member, you could take time off for a family member whose school has been closed. I didn't use the word child because the city council now says you can take time off for a non-child whose school has been closed. I do not understand the change, but they have done it. So now what you have, if you think about it, you had emergency paid sick leave, you have emergency expansion of FMLA leave, you have now Washington paid family leave, and then you have paid sick and safe leave laws. You have Seattle's specific one, but then you also have the state of Washington's one. So you have 12 weeks, you can have up to half a year almost if someone is suffering a serious health condition because of COVID-19. So there's been a substantial change in the laws because of COVID-19. I always tell people, look at your handbook. Often the handbook may promise more leave than the law requires. And so that may be an addition to, your exposure. The Department of Labor did state it's not unlawful to change prospectively your leave policies to reduce your cost. But you can't obviously focus on people of a certain age or certain health condition, but it's not unlawful to change in the future your paid leave under your own handbook and policies. Our governor got into it. Governor Inslee, he had a proclamation which said high risk employees, those have workers' rights. So the governor adds protection to certain individuals, and those are people who are 65 years or older, or they're in the CDC's increased risk categories. What do I mean by that? People who have cancer, kidney diseases, pulmonary diseases, they're immunocompromised. Those individuals are high risk individuals. These people have certain rights that did not exist before COVID-19. What are those rights? Well, number one, if you're a high risk employee, you must be given the choice of an alternative work assignment. And what I mean by that, they must be offered telework, a different location. They're completely different than the other employees. So even though you return to work, the business is open. If you're a high risk individual, you as an employer have an obligation to ask that individual, if they ask, of course, do you want to work telework? And you have to see whether or not that would work. If that doesn't work, then you let them use all their accrued leave. During the time of this COVID-19, you must maintain their benefits while they're off the job. And more importantly, and a big change is you can't replace high risk workers permanently. In other words, if someone can't work because they're a high risk individual and you find a temporary employee to fill their job, they get their job back when the risk has passed. That's a big change in the law. Under the ADA, the disability law, you're only required to reasonably accommodate a disability. No one's job protected. Under Governor Inslee's proclamation, there's job protection for high-risk individuals, which takes us into disability law. ADA in the Washington's version, Washington Law Against Discrimination. Do you need to reasonably accommodate someone with a disability? And how do you reasonably accommodate that person who has a disability because of COVID-19? Is COVID-19 a disability under the law? Well, the standard rules are an employer has an obligation to reasonably accommodate an individual with disability. What does that mean? Well, I'll make changes to the job so that the employee can perform his or her job. Some of the obvious accommodations under COVID-19 is teleworking. So if someone has a disability caused by COVID-19, or they're in high-risk individuals we just talked about, so they cannot come to work because of the risk they face, you may need to allow them to telework or take leave or change the workplace. So if you have an individual who cannot perform his or her job at home, so they can't telework, what must you do? Well, under the ADA, you're going to need to reasonably accommodate this individual at work. So think about these issues: masks, one-way aisles, plexiglass separators, barriers, reduce their contact with other individuals. These are reasonable accommodations the employer must consider if the employee cannot do his or her job at home. What if an individual cannot wear a mask? Well, some of the same issues we just talked about. That you have to discuss whether or not they can telework. Should they have an unpaid leave of absence? Should you give them something else besides a mask, a bandana, a face shield, flexible glass? All these things are required now with COVID-19. What if it causes undue hardship? I'm sure most people have gone to the grocery store or gone to the bank or somewhere else and seen plexiglass everywhere. What if you financially cannot do that? Well, the Department of Labor has recognized that undue hardship is a defense. Usually it's a weak defense. When we say in our litigation, my client could not reasonably accommodate this individual because it would be an undue hardship, it's usually blown off as a bad defense. Well, the Department of Labor says in this situation under COVID-19, we can understand how expense could be an undue hardship. And the Department of Labor says courts need to take into account the impact of reduced discretionary funds due to the pandemic. So it's all to say is that you as an employer, if you have an individual who is suffering from a disability that's going to be exacerbated by COVID-19 or his or her condition, so they can't wear a mask, you have an obligation to engage in the interactive process to find out if you cannot change the workplace. Is COVID-19 a disability? I mean, I think that's a very big question, because under the federal law, the ADA, a disability is a health, a medical or physical condition that substantially impairs a major life function, and it's not temporary. Most people would argue that COVID-19 is a temporary condition and it only temporarily impairs a major life function. The Washington Human Rights Commission has taken care of it for Washington employers and come out and ruled that a positive COVID-19 test is most likely a disability. So in that sense, if you're working in Washington, you can take the position, or you can be sure that most courts will take the position that a COVID-19 diagnosis and the ramifications therefrom will be a disability, and that you'll be required to reasonably accommodate that. So, disability law and testing. So taking a step back, as a general rule, employers are not allowed to test individuals for their disabilities. It's unlawful. Asking questions, taking tests to ferret out that someone has a disability violates ADA. COVID-19 has changed that. So the question people ask is, can I test for COVID-19? Answer, yes. Can I exclude an employee who has COVID-19 from the workforce? Answer, yes. That is a very, very big change in the disability law in reflection of, in light of the pandemic that we're having in the United States. So the EEOC advises that workplace testing is acceptable and does not establish a disability. It's not unlawful. The type of test is clear the EEOC has rejected antibody testing and has advised people take viral molecular testing. You, as an employer, can have symptom screening. In other words, you can require every employee to take a temperature check, even though that probably will disclose whether or not an individual has a disability. You can ask an employee, is he or she experiencing the symptoms of COVID-19, even though that is designed to determine whether or not that person has a disability. And if the employee refuses to comply, won't take the test, won't answer your questions, won't wear the mask, you can refuse to retain that person because of the situation, because of the safety concerns. What can you not ask? Number one is you cannot ask an employee if he or she has COVID-19 or symptoms if they're teleworking. Why? If they're teleworking, they're not exposing anyone at work and you do not have the same safety concerns. Two, you may not ask your employee if any family member has been diagnosed. That violates the GINA law, which has to do with genetic discrimination. Number three, you may not single out for questioning the older employees or the people who you think are sick. That will be disability discrimination. And you cannot tell finally, you cannot tell other employees that John has been diagnosed with COVID-19. That's unlawful. You just have to say another employee in the workplace has been diagnosed with COVID-19. Cannot identify the individual. That's because medical information must be kept separate and confidential. You may not share it with other people or it violates the ADA. Unemployment. Has unemployment compensation been changed by the impact of COVID-19? Yes. For the first time, the government has created a federal unemployment compensation plan. So the CARES Act, which was in place until July 31, provided an extra $600 per week to people who are unemployed because of the pandemic. That was a new creation of the federal government. Since that has sunsetted, there was an executive order passed adding an additional $300 per week. It's supposed to run out now. Congress and the administration are negotiating an extension on the pandemic unemployment assistance to help people out. What's interesting about the CARES Act and the pandemic unemployment assistance is it expands unemployment to people who are not normally covered. And what I mean by that is independent contractors, part-time employees. The federal government has ignored those facts. And if you are no longer working because of the pandemic, you can obtain assistance due to that. What about Washington? Well, as people probably know, at the Washington Employment Security Department, you get unemployment if you're terminated from your employment, as long as it wasn't for misconduct, or if you voluntarily quit. So people who've now been who've been terminated, put on furlough, so they're not working, they're entitled to get unemployment. The question is, what if they decide not to return to work? And the answer to that is they do not get unemployment if they don't have good cause to return. But if they have good cause not to return, they will continue to receive unemployment. What is good cause? Number one, high-risk individual. We talked about that with Governor Inslee's definition, or living with an individual who's a high-risk person. So those individuals may continue to receive unemployment compensation. Number two, the employee submits that the employer is in non-compliance with work safety guidelines. In other words, they say you, the employer, have not taken steps to protect the environment. You have not put up plexiglass, you have people working too close to each other, people are not wearing masks. If that's true, the individual has good cause not to come back to work, and he or she may continue to get unemployment. And finally, an addition that the governor passed is if the employee must provide care for a family member because of school or daycare closure. So that takes us back. Remember how we started today is you have 80 hours of paid sick leave to care for a family member. You also get up to 12 weeks to care for a child because the school is closed. Once that leave is done, you're generally required to come back to work unless you have paid Washington paid family leave or some accrued paid sick leave. But once that's all gone, you need to come back. Well, the law has been changed to say once that's ended, the employee may still continue to receive unemployment if they need to care for a family member or because school is closed, so that people still receive money. What is no good cause? In other words, what can a person cannot assert? And the law is you cannot refuse to return to work because you fear COVID-19. And employers should report individuals who don't return to work to ESD so they don't continue to receive unemployment because they're contending they're fearful. The only reason why they can't come back are those three reasons we went over. Probably the biggest risk area is wage and hour law under COVID-19. It's easy to understand that you need to give someone 80 hours and then 2/3 of their pay for FMLA leave. But wage and hour is always the hot spot because it doesn't require intent to discriminate. You don't have to intend not to pay someone their wages to have liability. And under COVID-19 and what the impacts of the pandemic with people working at home, there is some serious remote wage and hour work issues that you have to anticipate as an employer. So let's go through them. First one is hours worked. Now, non-exempt employees, so regular hourly workers, are paid for only the hours they work. And you as an employer may reduce their hours work or reduce their pay prospectively because of COVID-19. You're not required to give them pay because you've been shut down to a quarantine. You're not required to provide them hazard pay because they come back or they're working somehow as an essential worker in the pandemic. But you are required to pay them for all hours worked. And even if those hours are not authorized. In other words, if you have employees working for you, even though you haven't authorized them, off hours, responding to emails, responding to text, doing projects on the side, working on Saturday, working on Sunday, those hours are compensable. You have a duty to monitor your employees if they're working at home. Now, the solution the Department of Labor has suggested is implementing time reporting procedures so you can capture all hours worked. Number two is exempt employees, so salaried managers, the HR person, the accountant. What do you do with these salaried individuals? Well, you need to pay salaried individuals their entire salary in a week if they perform 1 minute of work. So if you don't pay them their entire salary, if they work 1 minute, then you will lose the exemption. Now, currently the minimum salary for an exempt person is 684 hours a week. So there is a solution to that. An employer can deduct from a leave bank that the salaried worker has if they're not working. So if John works Monday, then takes off Tuesday, Wednesday, and Friday, but has an accrued leave bank, you can take that leave bank time and put it there without losing the exemption. But if you don't have any leave, John gets his entire salary for the week. The next thing is the continuous workday. The Department of Labor has a rule that says an employee is compensated from the time of their first activity until their last activity. That's known as the continuous workday. With the pandemic, the Department of Labor has recognized there's a lot, people want to have flex time. They want to work a little bit, care for their children or a spouse, and then go back to work. And the Department of Labor has agreed that the continuous workday does not apply in order to make it easier for employers or really give employees flexibility so they don't have to work straight through their straight hours and the day is over. By the way, under the pandemic, the Department of Labor has recognized that exempt employees may now temporarily perform non-exempt duties. Think of the coffee shop, this coffee shop manager. She can now do a lot more work that would be considered non-exempt because there's a reduction in employee count during the pandemic. Telecommuting. Employers may mandate telecommuting. So employees can't say, well, we're shut down now. I don't want to work because of the pandemic. The employer may mandate that. And if the employee doesn't telecommute, you may terminate that person's employment unless, and I put that in capitals, unless that individual is taking a covered leave. So if the employee is at home because of emergency paid sick leave, you cannot mandate telecommuting. Emergency family leave, taking care of a child for 12 weeks, you cannot mandate telecommuting. Under paid safe and sick leave, you cannot mandate telecommuting. Taking Washington paid family leave, you cannot mandate telecommuting. But in all other cases, it can be mandated. So let's summarize some remote work issues. Compensate for all hours worked, even if overtime isn't authorized. Remember that when they're working at home, it's like working at the office. The employee must get their paid rest breaks every up to every 4 hours, a 10-minute paid rest break, and after 5 hours of work, a 30-minute unpaid meal break, and that is mandatory. You can reduce the rate of pay if you wish, but it can only be done prospectively. What about at-home work costs? I've had a couple clients ask me about that. Internet, computer, phones in the state of Washington and under the federal law, it's not required to be reimbursed. At this stage, it is not something that you have to worry about, at least from a legal perspective. So I have some best practices for employers in the wage and hour area, because this is really where people get sued, not because they're doing something wrong, but because employees are not taking breaks, employees are working around the clock, they're responding to text while they're watching Netflix, and this is compensable work. So, 1, reiterate timekeeping policies. Tell the individual what is appropriate and what is not appropriate. 2, set a schedule. It's easy for someone to work a substantial amount of time they don't have a schedule. Establish boundaries. It's kind of the same rule, but say do not work beyond this period of time. And same thing with you. Don't be emailing and texting your employees outside of their schedule, or they're going to respond. Identify gaps in the timekeeping system. What I mean by that is, why is there time missing here, or why is there so much time here? Figure that out. Require the employees certify time work. In other words, they sign off on I certify this is the true and accurate hours that I worked. Train your supervisors to be vigilant. HR professionals can't do all the work. The owner can't do all the work. Supervisors have to look at the time cards and be on top of it. Don't be asking employees to do things off hours. Remember the meal and rest breaks. It's just an area that people forget. Avoid salary basis issues. If a salaried employee works an hour during the week, pay that individual their entire salary. Pay attention to expenses. And finally, listen to employees when they're working at home. In other words, if they're telling you, I'll work on that later tonight, ask yourself, are they working outside the established schedule? Those are ways to minimize your wage and hour risk. Let's talk about OSHA and WISHA. OSHA has a general duty to maintain a safe workplace and for you to mitigate your health and safety hazards. That means as an employer, you have a general duty to provide a safe workplace. The workers' compensation bar, of course, acts as a safety net for you, that if an employee is injured, i.e. they contract COVID-19 at work, they can't sue you for personal injury. They can go to workers' comp, they can be paid, they can get time loss benefits, but they can't sue you. So what do they do if they contract COVID-19 at work, if they can't sue you? Well, number one, obviously they can file a complaint with OSHA or WISHA about a safe workplace, because you have a general duty to maintain a workplace. OSHA puts out a published safety guideline. The guidance tells you specifically how to provide a safe workplace under COVID-19. Talks about developing an infectious disease response plan, about creating workplace flexibility, increasing ventilation, and having administrative controls. And what I mean by administrative controls, how to minimize contact, other things that will help you provide a safe workplace. Telecommuting, this is interesting. OSHA has no regs that applies to telecommuting. So if people are at home, there's no specific rules. Number two is they're not going to inspect home offices, which is good. So the big issue with OSHA and WISHA is not so much of providing a safe workplace. That risk, if you don't, you get a fine. The bigger issue is if you fire some employee for reporting you, to going to OSHA or WISHA saying that there's an unsafe workplace and they file a complaint. You can take no adverse action against that individual, even if the complaint is without merit, even if the person is simply wrong, because that would be considered unlawful retaliation. And the other big issue with OSHA is record keeping requirements. You're now required to keep a notice if you have a confirmed COVID-19 case, and then you need to investigate whether or not that COVID-19 occurred at work, if it was contracted at work. That's the requirements under the new rules related to OSHA or WISHA. There's some very specific guidelines for construction that you can find on the OSHA.gov page, and it relates to construction. So if you put in OSHA.gov, construction, these specific guidance will come up. You need to screen all visitors on the construction site for symptoms of COVID-19. They want you to adopt staggered work schedules. Don't have everyone come and start at the same time. Have the trades come at different times. Identify choke points on the construction site, the gates, and try to make those not so small, expand them. In elevators, ensure 6 feet distance. So you probably have all seen that in elevators with the 2 round circles. They're 6 feet apart, and make sure that equipment operators are wearing the appropriate PPE. If you go across I-90 right now on the floating bridge in October of 2020, everyone's out there working, but you can see all these individuals who are working out there are working in a mask. And so clearly they're enforcing OSHA's guideline. And for those who are in close contact within 6 feet, make sure they have PPE. In other words, you need to have at work masks to hand out to your employees. The Washington Department of Labor and Industries, they have some very specific rules for workplace. They have mandatory social distancing. They require frequent hand washing. They have procedures on how to address sick employees. They talk about PPE, what you should have, what you shouldn't have, and talk about employee education. All this can be found on the Washington Department of Labor and Industries COVID-19 response page. Thank you very much. I appreciate this time, having an opportunity to speak to you about COVID-19 and the impact it has on law and on employers. Good day.